Good afternoon, good morning, good evening. Hope everybody's well. Please like, please subscribe, please share, please comment, please do whatever else you want with this stuff. Today I was going to talk about how brokers take our constitutional rights without telling us. And I will get to that in a second after I've, of course, set up what we're doing here today. Of course, this is not legal advice. Please show your pets and your plants and whoever else what area of the Constitution is involved when you add nutrients to the soil. The First Amendment. The Constitution says I have the right to bear arms, I told the officer. He said, "Where's the rest of the bear?" What's the difference between prostitution and the Constitution? One has its pros and the other has its cons. And last but not least, when I was a teenage boy, my mother caught me with a copy of the Constitution. I told her I was just reading it for the articles. Anyway, wanted to talk about how brokers take our constitutional rights. And obviously, I've just participated in a arbitration with Fidelity. And if anyone is interested about what went on, please see the video. And if you have more interest, please reach out to me. I can certainly fill you in on details, etc. But how do we get to arbitration? So I believe in almost all of your customer agreements, and the other agreements could be in the share lending agreement also. I think it would be. And I think their idea is to have them in all agreements. There is a arbitration provision. In Fidelity, I'm looking at a Fidelity document, there's something called a pre-dispute arbitration agreement. It's specifically laid out in the contract that you sign, that you probably don't read, and is at the very end on purpose. So before you sign, wherever you sign, this is what you see, so that if you were in court, they would be able to say, we stick it at the end of the contract, so right before they sign, they cannot help but review this provision. Now, nobody tells you about this provision. It doesn't say anything about your constitutional rights, and I'm reading now just from the Fidelity one, but all of them are going to be the same within reason, with subject to some modification. And Fidelity also has a limitation provision. So there's a provision that provides, instead of the right to jury trial, that you give up that right and you have to go to arbitration that's run by FINRA or something like it. But on top of that, in that contract, you're limited from receiving recovery for certain things that go on relating to execution of trades, relating to incidents of world events, relating to things like U3 halts and those kind of events. So in your contract, you may have both an arbitration provision and something called limits to our responsibility or limitations of liability or something along those lines. And with regard to, and I'm going to focus on the Fidelity one because that's the one that's most involved, nowhere do I see, does it say that I'm waiving my constitutional rights. And you have, just so we're clear, you have, besides other rights, you have a Fifth Amendment right to due process, also that can be read into the 14th Amendment. You also have a Seventh Amendment right to jury trial. So if you have a federal claim of more than $20, which would, I'm sure a securities claim would fit within that, then you can file and you can get a trial by jury, and that fact finding by the jury cannot be disturbed. And that's what the Constitution says. So you have a right to a jury trial. So what is this agreement and all the agreements we sign say about the Seventh Amendment? Nothing. Doesn't say anything about the Seventh Amendment. What it says is all parties to the agreement are giving up the right to sue each other in court, including the right to a trial by a jury, except as provided by the rules of arbitration forum in which a claim is filed. And I'm not aware of anything that's going to, in any forum, that's going to permit a right to jury other than what's referenced there. So here, the very first start of this pre-arbitration dispute, they take away your right to jury trial. And it doesn't say that's a constitutional right. You know, perhaps for some people, if it said it was a constitutional right, they would not sign the agreement, which is another issue is generally, if you have the right to find an agreement that doesn't contain an arbitration provision, then it would not be an unconscionable agreement. So you would have at least some opportunity to find something that's fairer. But with these finance agreements, they're almost all going to have arbitration agreements like they have in real estate contracts and perhaps auto agreements. So you really have no opportunity to find anything else that doesn't give away that right to a jury trial. So you're kind of stuck. So should they be allowed to collectively remove that right? You know, I think not. And if they are, shouldn't they say that they're removing your right to a jury trial per the Seventh Amendment of the Constitution? Should it specifically be set out so we really know what you're doing here and you don't disguise the practice? And again, should that be allowed, or should Congress pass laws permitting retail to have a real remedy? Because as of now, the remedy that's provided through brokers is a right to an arbitration. We know that arbitrations are, and I haven't got through the rest of this contract, but we know that arbitrations are one-sided. So should it be that way, or should we have the right to go in front of a federal court, or should the arbitration not be binding, or should discovery be open so we could have the ability to find out the facts necessary to prove up our case? And MMTLP is a perfect example of this. So MMTLP is not a typical example of the disputes that you would have with FINRA involving a customer, like a retail customer, and FINRA. Most of those would be probably you told your broker to sell something and they didn't, or they did, or something along those lines. And in such types of disputes, just getting your contract and your customer records, your trade records, is probably sufficient because that's what it is, and then there'll be testimony, etc. But the MMTLP matter, for example, involved third parties, it involved governmental agencies, it involved SROs, and it involved situations out of the norms. And besides the fact it involved a U3 halt that should have been enough to stimulate and encourage and permit discovery, the parties were not permitted to get discovery beyond typical, which again was the account records. And under the FINRA arbitration system, the right to discover is extremely limited, and only relates again to the type of disputes that FINRA has been used to adjudicating, not the type of disputes like with MMTLP involving outside parties. And anyway, so that's one of the defects in the arbitration process and the discovery process. So what additionally does this agreement say? So first of all, it says it takes away our right to a jury trial. Next, it says arbitration awards are generally final and binding. A party's ability to have a court reverse or modify an arbitration award is very limited. And that is an understatement. So the courts use arbitration, obviously, to adjudicate cases because they don't want to have their courtrooms filled to the rafters with people. And here, in fact, arbitrations are taking off a burden from the courts. So the judges like that. And the way the rules are written, absent some extreme circumstance, really, it requires an extreme circumstance, the awards will stand up. And I've had probably, I was thinking during all my years, and I've done many arbitrations. I'm sure I've done 100 arbitrations, guessing. Probably 2 or 3, I was able to get a reversal. One of them involved a federal judge who was conducting an arbitration. But the ability to get a arbitration award reversed, extremely limited. It's got to be an extreme goof by the arbiter. Basically, that's it. It's got to be an extreme goof that was disclosed and wasn't acted upon. Basically, that's it. I'm sure there's other possibilities, but that's kind of what stands out to me. And again, very limited. Even when you think it should be, they basically rubber stamp because that's their purposes. So they're telling you here you have very limited ability to get it reversed, and I'm telling you it's almost nothing. So you should presume if you got an arbitration award, that is a final reward. And the way it goes is you're before an arbiter, they produce a final award. To get that confirmed into a judgment, you have to take it to a court. The court will look at it, and if they agree, they'll confirm it. And again, the burden or the intention of the court is to approve the rulings of the arbiters. So when I say it's very limited, it's beyond that. So you've given up the Seventh Amendment right. You've given it also basically your rights to appeal, which probably also is a violation of, or at least arguably could be a waiver of some due process rights and Seventh Amendment rights, and probably should be referenced as such also. Third, the ability of the parties to obtain documents, witness statements, and other discovery is generally more limited in arbitration than in the court proceedings. Now, if you watched my arbitration videos, and I did several, my ability to get witness statements, documents, and generally discovery was entirely suppressed by my opposition and, most importantly, by the arbiter. So I had no right to obtain relevant discovery, that including depositions of people from the SEC and FINRA, Sam Draddy, for example, Patricia Casamates, and other people like that who were reflected on FOIA documents in December of 2022 in the MMTLP situation. That included any and all documents related to discussions between Fidelity and the SEC and FINRA with regard to the U3 halt, what was going on in MMTLP, at or about December 2022, the time that's the relevant time. It also included the failure to produce documents related to the inability of Fidelity to actually sell the shares, period. That was known because I produced a document that said that. So that would go, and that also included not having to identify people with knowledge. So these are all types of discovery that this contract suggests might be more limited, but is an understatement saying that you have no ability, in essence, to get relevant discovery unless it's a very limited dispute about, as I indicated, about a trade or something along those lines. The arbitration system is not set up to deal with more complex disputes that require more complex discovery. So no right to a jury, take away our Seventh Amendment. No right to limited right to appeal. So we have a Fifth Amendment and a Seventh Amendment issue. No right to obtain discovery. Again, another Fifth Amendment and Seventh Amendment issue. And I'm talking about these, and nowhere in the agreements does it talk about a Seventh Amendment or Fifth Amendment release or a constitutional waiver, anything like that. It just takes away the right quietly without you being disclosed to you. And D, the arbiters do not have to explain the reason for their award unless in an eligible case there's a joint request for explained decision that has been submitted at least 20 days before the party. So in my case of the defendant, Fidelity was not going to request that. So there's no way for me to get a reasoned ruling. So you can imagine you go through an arbitration, you're paying for this, by the way. This is not free like in a court. In a court, theoretically, it's free. Here, you're actually paying for it. And they don't have to give you a reasoned analysis for how they decide. Not only that, they don't have to give you a reasoned analysis or a hearing on motions that you filed. So if you want to seek, as I did, documents in the arbitration, they don't have to hold hearings. They've already said they don't have to give you a reason, and that's how they conduct themselves. But they don't tell you, again, that would seem to be a deprivation of Fifth Amendment, Seventh Amendment rights. There's no reference to that they're depriving you of a constitutional protections. And then E, The panel of arbiters may include a minority of arbiters who were or are affiliated with the securities industry. So they're telling you, you give up your right to jury, you can't get a discovery, there's no appeal rights, the arbiters don't have to explain their reasons, and they might be in on it because they're working for the securities industry. So how could that not be fair? How could not that obviously be a further violation of your Fifth and Seventh Amendments? Because how could that be a fair proceeding? And as you followed, if you followed the arbitration as it went on, in no way, in no planet, on no world, in no universe, for no party was that a fair proceeding. And I've participated and handled, as I said, numerous dozens of arbitrations. And by far, this is the most limited that you could ever get. So we talked about the constitutional rights you just gave up, and nobody told you that, and it's going to be in every agreement. And is that right? Shouldn't that, number one, have to be disclosed in clear English? And two, should it not be excluded? Should they be permitted in a arena where retail has limited leverage anyway to take advantage of retail by having these type of limitations on proceedings? Doesn't sound like it to me. So now we go on top of that. So what is covered by this? And then when it goes into that, it says all controversies that might arise between you and us concerning any subject matter. Now, is that broad enough to cover everything? Yes, it's broad enough to cover everything except for class actions that are not discovered, that are not covered. So we have this, which is clearly a waiver of your constitutional rights without disclosing you're waiving the constitutional rights. Whether Congress should do something about that and make the arbitration proceedings fair, at least permit you to have reasonable discovery, to have some appeal rights, to have some ability to control, really control the arbitration selection process, and having the ability to get discovery to be able to do your documents. But what's interesting is there are other contracts that you engage in on a daily basis where you also have arbitration provisions, and all of them are different. So you have real estate contracts, and so if you hire an agent, for example, to do sell your house, there'll be an arbitration provision. If you end up in a dispute with your arbiter, then they have arbitration. Now that may be conducted before the American Arbitration Association or some other body other than FINRA, for example, that are let's seemingly not objective. And I think automobiles might have it, and there's plenty of other things that have arbitration provisions. So the bottom line is, before you engage in a significant transaction, you should look at the document to see if it has an arbitration provision and what it is. And if it's a transaction that you're not sure of engaging in, or you're concerned about possible disputes or issues that might arise, then if there's an arbitration provision, you should take that into account. If it's a 50-50 on a transaction that has a arbitration provision that you're not comfortable with, maybe you should consider not doing that. But there's going to be in all types of contract. You certainly can ask them to be removed, although oftentimes they won't. But you should at least be familiar with it. Now, some contracts, it may refer to mediation and arbitration. So what is that? What's the difference? Mediation is an informal process. So mediation is a third party comes, tries to negotiate or act as an intermediary between two parties trying to negotiate a resolution of the case. It's informal, non-binding, and these are all confidential, by the way, the contents of it. Arbitration is actually, like, in effect, a mini trial where parties put on evidence subject to whatever the rules of evidence that the arbiters are willing to enforce, and they'll issue an award. Arbitration could be binding or non-binding. There are both of those. FINRA, unfortunately, they're binding, not non-binding. When they're non-binding, you'll still get a result, but then you could take it to court. These are binding, so it is whatever it is. As I indicated, you could contest it in a court, but generally they will uphold the outcome. So bottom line is there are a lot of contracts where you have arbitration provisions. You should really be sure about them before you sign. You've been given kind of a heads up as to what the difficulties are and costs. Again, in my particular arbitration regarding MMTLP, a person paying legal fees for my case would not have been able to do it. It would have just been way too expensive. So that's something you have to keep in mind, whether you actually have a remedy. And if you don't care, that's fine. But if you do care, you should keep it in mind. And again, ask for things to be stricken in contracts if you're not comfortable with them. And if they're not, then reconsider doing it. Understand the differentiation between mediation and arbitration. Remember to look in your contracts for any limits of liability that also might be referred to as limits to responsibility. And don't ignore this stuff. And last but not least, look to see if there's an attorney's fee provision in these contracts. Usually would be located near any type of arbitration provision, and look to that to see if there in fact is an attorney's fee provision. An attorney's fee provision would say that something along these lines. The prevailing party in this dispute will be entitled to its reasonable attorney's fees and costs. So in a lot of these arbitration agreements, they don't have those because the financial entity is willing to pay legal fees as a part of their cost of doing business and knows for the regular consumer, it might be difficult to do so. So look to see in agreements if there is an attorney's fee provision, because that will give the consumer added leverage if there happens to be in those cases, especially if you're correct. Anyway, so I hope that defined for you why I believe there is that brokers just take away our constitutional rights, including our rights to a jury trial, our rights to due process, without disclosing they're doing it. And there is no alternative, and Congress should act to change the rules. To the extent I don't think FINRA should exist and should be immune, that should be the first rule that is changed, removing immunity. But to the extent that further arbitrations go forward, they should be changed. So discovery should be open. So there's rights of appeal so that the judges are not biased, and all those indications. Really is discovery that's the biggest hurdle at this point in time, the right to discovery and the limitations that arise. Anyway, hopefully that helps provide some food for thought. If you have comments, suggestions, please reach out. Everybody be well. Talk to you soon. And